Which is better, dismissal with prejudice or without prejudice? It sounds complicated. What does that even mean? Well, if you're interested in the criminal law or you have a case where this might apply, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I have a law firm in Washington State that's been defending people charged with crimes for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now just jumping right into it. Dismissal of your case. Yay! Great news, your case is getting dismissed. But is it going to be dismissed with prejudice or without prejudice? Which is better? I mean, does it even make sense, those words? So you would think, I think most of the clients that we talk to would prefer in their mind that a case be dismissed without prejudice, right? Prejudice is bad, right? You know, I'm not prejudiced. Why would I want that word? And interestingly, it's pretty much the opposite. So dismissal without prejudice, let's say the prosecutor moves to dismiss your case. I move to dismiss Mr. Smith's case without prejudice. Well, without prejudice means without prejudice to the state, to their ability to refile the case if they choose to. So in criminal law, there's a concept called jeopardy, right? Have you ever heard, hey, you can't be put in double jeopardy? And I'm not talking about the TV show. I'm talking about jeopardy as it relates to the Constitution. So you're not supposed to be able to be tried twice for the same offense, right? At least at the same level. You can get tried twice for the same thing. You've seen it before, state level and federal level, but technically those are different statutes. But let's make it simple. You've got a DUI case and the state moves to dismiss the case without prejudice. And that happens like if you get a blood draw and the blood result isn't back. It's pretty common for like the Everett court, for the prosecutors there to dismiss cases without prejudice. Yay, my case is dismissed. Well, jeopardy hasn't attached in that case. So if it's dismissed without prejudice, that means that prosecutor can go ahead and refile your case once the blood draw shows up. Okay? When does jeopardy attach? Well, the only time jeopardy really attaches, which means if the case is dismissed, you cannot be retried, is once a jury is sworn in a jury trial, or once the first witness is sworn in what's called a bench trial, a trial before a judge. So if the prosecutor moves to dismiss your case with prejudice, and that's how the court grants the dismissal with prejudice, that means that case can never be refiled again. That DUI cannot be refiled. That assault cannot be refiled. So why the heck would a prosecutor ever dismiss a case with prejudice, or why would a court dismiss a case with prejudice when they don't necessarily have to, right? Without prejudice means I can do the case again if I'm the prosecutor, and with prejudice means I can't. Well, I think I'm somewhat qualified to answer that because I was a prosecutor for 7 years before doing defense for the past 20 plus years. So prosecutors at times, they want to be fair. If a defendant has done a lot of work, the defendant has done some classes and done some education and things like that, the prosecutor might think it's fair to dismiss the case with prejudice because of sort of how much the defendant has worked at earning that dismissal, how much that defendant learned and made the most out of the crisis by doing maybe educational classes, things like that. Another reason a prosecutor might dismiss a case with prejudice is they just don't want to deal with it again, right? Maybe they have an opinion they can't prove the case, and the alleged victim is really mad that they're going to dismiss the case. Well, if they dismiss it without prejudice, then they could get pressured into having to refile it, right? If they dismiss it with prejudice, it's done, right? No one can do anything. And again, you've seen in my other videos, everybody is self-interested. Everyone does things for whatever reason that appeals to them, that makes it good for them. And so, while I think it's pretty common that a prosecutor, if they move to dismiss, will be without prejudice, oftentimes we can see cases where they'll dismiss with prejudice. So what about other types of dismissals, right? What about dismissals that aren't the prosecutor choosing to dismiss the case? Well, then that can be up to the judge, right? Now, in a motion hearing, if there's a case that goes to motion and the motion is, hey, dismiss this DUI charge because the cop made an illegal stop, and everything after the stop is fruit of the poisonous tree, which means the state has no evidence, and I move to dismiss the case, oftentimes the judge will dismiss that case with prejudice, okay? They still have the option to dismiss without because the state could come up with other evidence later, right? It's a little bit factual dependent. Let's say the state is missing a witness, we say you can't go forward without the witness. Yes, they dismiss the case. The judge dismisses the case over the prosecutor's objection. It doesn't have to be with prejudice. The judge could say without. But sometimes the judge will really make that point. No, this is with prejudice. You're done, state. Don't ever bring me this beep again, right? So that's a situation where it could go either way. If, however, a jury is sworn in, right? And the first witness testifies, and then something goes terribly wrong, and there's a mistrial. The court could dismiss that case because the jury's been sworn, or in that, and there's also a situation where they don't have to. However, if it goes to verdict and there's a not guilty finding, that is absolutely with prejudice. That case can never be refiled. It just can't be done. So, what's an example where, if your case is dismissed without prejudice, what's an example where that can come back to haunt you? And so, for the most part, I think I want you to know that don't worry too much about if it's with prejudice or without. It would not be a great idea to really say, well, I'm only taking that dismissal if it's with prejudice. Let's go to trial otherwise and then risk a chance of losing. That's probably not very smart, okay? So I don't want you to worry about it for the most part. This is, education, but I have seen a situation where a prosecutor moved to dismiss an assault charge, okay, without prejudice because at the day of trial, the witness wasn't there. So the prosecutor was smart enough to know, hey, I can dismiss now without prejudice. If the court grants it without prejudice, jeopardy hasn't attached. We haven't sworn in a jury. And if I want to, I could refile this case at some time. And why we don't really worry about that is usually the prosecutor's not going to want to, right? They've got so many things to do. If the alleged victim isn't interested, then why should they be, right? Because that type of thing. Well, I've seen a situation where a prosecutor moved to dismiss a case without prejudice. That was granted. And a few days later, they ran into the victim in a store. And they're like, I know you. Well, I'm going to refile this case and serve you the subpoena right now because I'm so mad at the defendant and so mad at you for not trying to help me prosecute. I'm going to refile this case. So there is a situation where if it's dismissed without prejudice, that it could really come back, but it's so rare that would happen. I've seen it once in my 20 years of doing defense work, that I really wouldn't worry about it too much. So I hope you found this useful to understand the difference of with prejudice, without. Again, prejudice means prejudice to the ability of the state to refile the case, and without means they can just refile it. So if you're getting your case dismissed, you can ask your attorney to argue for with prejudice. You can ask your attorney to ask the prosecutor to dismiss it with prejudice. But for the most part, don't worry too much about it. So if you found this useful, please like and please subscribe. More people will get to see this video and get the help they need. And more importantly, if you need some help yourself, feel free to give my office a call. Again, I'm Lance Fryrear. My law firm's been defending people charged with crimes for more than 20 years. We do that all throughout Washington State. And plenty of times we've got the with or without prejudice type of situation, which is good news. The case is getting dismissed. But if you have a situation, reach out to us. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.